Hello, everyone. Welcome to DriverCheck's webinar on ensuring compliance and understanding the Department of Transportation testing regulations webinar. I'm very pleased to be here today to welcome you. My name is Jonathan Davids. I'm an occupational medicine physician and a medical review officer and the corporate medical director here at DriverCheck. It's my pleasure to be hosting this webinar for you with one of my colleagues, Brandon Kearse, who I'll get to introduce in a minute. But I want to take a bit of time to tell you a little bit about DriverCheck for those of you who are perhaps new to the industry, new to drug and alcohol testing. For those of you who aren't familiar with DriverCheck, we are a drug and alcohol testing company. We do occupational medicine as well, but primarily started off in the drug and alcohol testing space in 1996. So we have about 28 years of experience and expertise behind us. And we provide a full framework of testing to interpretation, from collections of drug and alcohol tests, pushing that to the lab for lab interpretation and results, and then a full medical review by our duly qualified doctors who are medical review officers, certified medical review officers, who are able to interpret the forensic drug test results and provide support to you and your organization. In addition to that, normal process, we're also available as experts to help in cases of challenges. So with drug and alcohol testing, you should be expected that some of this might be contentious and it might be challenged, but our experts, our subject matter experts and our medical doctors are available to support you and your organization with any of those challenges, with providing expert letters and expertise if it's ever brought to a court of law. So all that to say, today is a special day. We wanted to spend a bit of time on regulations, specifically the U.S. Department of Transportation regulations. And for those of you who are new to drug testing and new to the DOT regulations, this webinar aims to give you a broad overview and tell you a little bit about this. It's sometimes difficult to navigate some government regulations, and Brandon, my colleague, is going to be here to explain this very simply to you. But for those of you who are already in the space and been doing this, this is a good refresher tutorial that we hope to supply you with and perhaps generate more questions at the end of the webinar. So a bit of housekeeping. We are in a Zoom call today. We will be having a Q&A session at the end of the talk. So for questions, there is a Q&A feature down at the bottom of your screen. If you hover with your mouse, you can find the Q&A section. Please type in your questions. We aim to get to as many questions at the end of our presentation so we can have answers for you. In the event that we can't answer all of the questions during the webinar, please know that we will be sending out a survey, and in that survey there is a spot. So if you do have questions, please put those down, and one of our DriverCheck representatives will be happy to reach out back to you to answer those. So without further ado, by the way, this will also be recorded and be provided to the participants on this webinar. So you don't need to screen record or take notes. We will be sending this out to you. So without further ado, I want to introduce the speaker. My job is easy. I just get to be the host. I want to introduce my colleague, Brandon Kearse. Brandon has been with DriverCheck for just about 6 years. He's our privacy and compliance officer. He is an expert in all things regulated, specifically the U.S. Department of Transportation rules and regulations on drug and alcohol testing. Prior to DriverCheck, Brandon has been was employed by Greyhound Canada, a large passenger bus company that you all may know. He was dealing with driver safety, both on and off the road, including driver schedules, workers' compensation, but more importantly, driver training and drug and alcohol testing for road safety regulations. So without further ado, I'd like to bring Brandon on and have him take it away from here. Brandon?
Thank you for that introduction, Dr. Davids. And as mentioned, I'm Brandon, and I've been with Driver Check for approximately 6 years now within a compliance role. And so this webinar, like Dr. David stated, is intended to be an introduction for DOT regulated employers who are new to US DOT and FMCSA drug and alcohol testing regulations. And it's also intended to be a bit of a refresher for those of you who have been around for a while and perhaps you need it. Okay, so on the agenda, I'm going to be going over the following topics. We're going to go over a brief history of US DOT drug and alcohol testing. I'll explain what the US DOT and FMCSA are and which regulations apply. I'm going to go over who's required to be tested and what tests are required. I'll cover supervisor training along with the various collection methods that are used and which drugs are to be tested. I'm also going to go over, um, you know, uh, the medical review officer process, as well as what's considered a positive alcohol test. And I'm going to inform you of the consequences for testing positive or refusing to test and how that relates to the FMCSA's Drug and Alcohol Clearinghouse. And we're also going to get into the return to duty process should someone have a drug and alcohol violation. And then we're going to have some time for questions at the end of my presentation. Now, before we get into it, I want you to know that this really is a brief introduction and a refresher to regulated testing, and it's not intended to be comprehensive, and it doesn't cover all aspects of testing. So without further delay, I'm going to get into it. So you might be asking yourself why the United States Department of Transportation, or the DOT for short, requires regulated employees to be drug and alcohol tested. Well, the answer is pretty straightforward, and it all has to do with safety of the public and safety within the transportation industry. And just a bit more history on that. We're going back several decades now. In the 1980s, the National Transportation Safety Board recommended that the administration of the US President Ronald Reagan implement a policy because of a growing number of accidents related to drugs and alcohol within the transportation industry. And the Reagan administration agreed that there needed to be a change. So the issue at the time, though, was that there was no specific legislation within the United States to um, say who could be tested and at what times for transportation employees. And this led to the president enacting the drug-free workplace program, which allowed for pre-employment testing and testing based on reasonable suspicion. So one example of one of these accidents that led to regulated testing took place back in July of 1988. So what happened was there was a tour bus traveling from Atlantic City to through New Jersey, near Bass River, New Jersey, and the bus careened off the road and struck some trees on the side. And it injured 44 passengers, one of those passengers being critically injured, while another was seriously injured. Okay, and that's just one example. There's many numerous examples, some involving fatalities. I mean, I could get into different railroad accidents involving Amtrak and other passenger trains where there was many more fatalities and collisions. But for the purpose of this, we're going to focus mainly on FMCSA. And so I wanted to relate and connect this to the trucking and buses industry. And so, following these various accidents, come the early 1990s, the United States Congress passed what's called the Omnibus Transportation Employee Testing Act. And I don't expect you to remember the name of that act. However, that's what spurred on and got these regulations, these testing regulations into place. And what that act did was it recognized that there was a need for safety within the transportation industry, that these employees, drivers, needed to be drug and alcohol free while performing their duties. And the act required that the various DOT agencies like the FMCSA implement drug testing for safety sensitive employees. And then it wasn't just trucking and bus industries either. It did go across the gambit of transportation. So we're talking aviation, the railroads, even the U.S. Coast Guard and mass transit industries, as well as pipeline. And then finally in 1994, the US DOT added alcohol testing in addition to the drug testing. And where this becomes relevant to us up here in Canada is when in 1996, the regulations, there was an interpretation of the regulation stating that, the testing is to be applicable to Canadian as well as Mexican nationals coming into the United States for commercial driving purposes. And just a quick fact on that, driver check actually got its start in 1996, as Dr. David said earlier, and that was to help the trucking and commercial driving industries with the required testing regulations. Now, you might be asking yourself, what are the DOT and FMCSA, and why should I care? Why even bother? Why does it matter? Well, the United States Department of Transportation is a federal cabinet of the United States government, and it's concerned with transportation, as the name implies. And the U.S. Secretary of Transportation reports directly to the President of the U.S. And the DOT's mission is to deliver the world's leading transportation system, serving the American people and economy through safe, efficient, sustainable, and equitable movement of people and goods. And why you should care about that is because it's the DOT that regulates the various transportation-related activities in the United States, including moving goods and people by truck, train, airplane, and other means. And the DOT regulations cover a range of issues related to transportation, such as drug and alcohol testing, reasonable suspicion testing, training, safety and security, and environmental concerns. So, for example, there are regulations related to the use and maintenance of commercial vehicles, as well as the transportation of hazardous materials and the qualification and training of drivers themselves. Now, the FMCSA, on the other hand, the Federal Motor Carrier Safety Administration, they were established as an administration under the Department of Transportation. And its primary mission is to prevent commercial motor vehicle accidents, including fatalities and injuries. And why you should care about the FMCSA is because they're responsible for ensuring safety in motor carrier operations through strong enforcement of the regulations. And they also target high-risk carriers and high-risk commercial vehicle drivers. And quite honestly, they're the ones, the FMCSA are going to be the ones, their auditors and their officers are going to be the ones that they're going to be on the roadside looking at the drivers, inspecting their trucks, and also issuing tickets or possibly even standing a driver down and possibly even telling a particular trucking company or bus company, you can't be on American roadways because we've considered you a high risk to the American public. Okay, that's why the FMCSA is important. And they work with federal, state, and local law enforcement agencies, as well as the motor carrier industry and various labor safety interest groups. So just moving along, which regulations apply to DOT drug and alcohol testing? Well, I'm going to give you a bit of a mouthful here, but Title 49 Code of Federal Regulations Part 40, and you don't have to remember that. We simply call it or refer to it as Part 40 in this industry. And Part 40 is a DOT-wide regulation that states how to conduct testing and how to return employees to safety-sensitive duties after they violated a drug and alcohol regulation. And Part 40 applies to all DOT testing regardless of the mode of transportation. So, for example, whether you're an airline employee covered by the FAA rules or a trucking company driver covered by the FMCSA rules, Part 40 procedures for collecting and testing specimens and reporting of test results apply to you. So each DOT agency specific regulation spells out specifically who's subject to be tested, when they're to be tested, and in what situations for that particular transportation industry. Now, on the other hand, the other regulation that's important here, and this is very specific to the FMCSA, Title 49 Code of Federal Regulations Part 40, or sorry, Part 382, or simply Part 382, is an FMCSA specific regulation that defines drug and alcohol testing rules and regulations for employees who drive commercial trucks and buses, as well as some limousines as well. And Part 382 identifies who's subject to testing when they're to be tested in what situations. And Part 382 also imposes various protections or restrictions on employers and service agents against the use and release of sensitive drug and alcohol testing information. And combined, Part 40 and Part 382 go over various items such as, who's to be tested, which substances are tested, and by substance, I mean like drugs, controlled substances, when testing occurs, what the testing procedures are, what happens if somebody fails or refuses to test, and the responsibility of the various parties involved in drug and alcohol testing, such as the employer, the employee, medical review officers, third-party administrators, laboratories, alcohol and drug testing collection technicians, substance abuse professionals, service agents, as well as various enforcement officials. Now, who's required to be tested under the regulations? So, like, who specifically need to be drug and alcohol tested? Well, the FMCSA, and again, I'm really honing in on the FMCSA here for this webinar. The FMCSA's drug and alcohol regulations require all people to be tested who operate a commercial motor vehicle in commerce in any U.S. state. And one of the following also have to apply. So that person has to drive a commercial vehicle having a gross weight rating or gross combination weight of 11,794 kilograms, or if you're using the imperial system, 26,001 pounds or more. Another stipulation, could be a person who drives a commercial motor vehicle carrying 16 or more occupants, and that includes the driver themselves. That would be like a bus or a large limousine. Also, this could apply to a person who drives a commercial vehicle of any size that transports hazardous materials that requires a vehicle placard. So like you can think of like a fuel truck. Also, just a very quick note, owner-operators that drive commercial vehicles within the United States, they're also subject to testing. So just because you own the vehicle and you drive it doesn't mean you get to escape the regulations. You still have to do drug and alcohol testing. Now, what this means overall is that most commercial truck drivers, as well as motor coach operators and even some limo drivers, are going to be subject to DOT testing if they're going to be driving in the US for commercial purposes. Now, there are exceptions, some notable exceptions to the testing rules, and the following types of drivers tend to be exempt from the testing regulations. So those people who drive a commercial vehicle for military purposes, like for national defense, farmers who operate a farm vehicle to transport agricultural products and farm machinery and farm supplies to and from a farm, they're exempt. Firefighters and other emergency response vehicle drivers, they're also exempt if they're operating that vehicle for the purpose of preservation of life and property. And also exempt are those drivers who operate a vehicle that is intended to remove snow or ice from a roadway if they're employed by a government. Now, if you aren't familiar with the types of drug and alcohol testing, here they are, like the various reasons. So we have pre-employment, post-accident, random, reasonable suspicion, return to duty, and follow-up testing. And I'm going to explain each one of these a little bit further so they each make a little bit more sense. So for the first one, as the name implies, pre-employment testing is conducted prior to the first time a driver performs safety-sensitive functions for an employer. So the employer only has to conduct pre-employment drug testing. They don't necessarily have to do alcohol testing in accordance with the regulations unless that employer chooses to do alcohol testing. So the employer has to receive a negative drug test result before permitting the driver to operate a commercial vehicle. And again, this is for DOT purposes. Now, post-accident testing, again, pretty self-explanatory. Drug and alcohol testing might be required following an accident involving a commercial vehicle if certain conditions apply. So if there's been a human fatality, there needs to be a test. If there's been bodily injury requiring immediate medical treatment away from the scene, so let's say somebody got hurt and they had to go to hospital, they need surgery, there needs to be a test for that. If there's been any disabling damage to any motor vehicle requiring a tow weight and the commercial driver received a citation, they'll need to go for testing as well. Now, random drug and alcohol testing, on the other hand, that's done uh, using what's called random selection, and the random testing is supposed to be spread out through the entirety of the year, the calendar year. Now, at the beginning of each calendar year, the FMCSA administrator sets the minimum annual percentage rate for random drug and alcohol testing based on the reported violation rate for the entire industry for the past couple of years. And so the random testing rate for this year, for 2024, is 50% of selected drivers to be tested for drugs and 10% of selected drivers for alcohol. And the selection of drivers for random alcohol and drug testing must be made by a scientifically valid method, such as a random number table or a computer-based random number generator that is matched with the driver's identification numbers or some other comparable ID number. And each driver selected for random testing under the selection process must have an equal chance of being tested each time selections are made. And to calculate the total number of covered drivers eligible for random testing throughout the year, as an employer, you need to add the total number of covered drivers and divide that by the total number of random testing periods. So as an employer, you can use a service agent to perform these selections for you. And your covered drivers can also be part of a larger testing pool, or what we refer to as a consortium. So you might decide you and several other trucking or bus companies are all going to come together and have one large random testing pool. And on that point, driver check can certainly help you with random testing selections. Now, next is what is referred to reasonable suspicion testing. And drivers who appear to be under the influence of drugs or alcohol should be immediately tested. However, there are some specific requirements for reasonable suspicion testing to take place. So according to the regulations, the employer's determination that a reasonable suspicion exists to require a driver to be tested has to be based on a specific contemporaneous, articulable observations concerning the appearance, behavior, speech, or body odor of the driver. And also important is that the determination to test for reasonable suspicion must be done by a supervisor or company official who is trained in the observation of drug and alcohol use. And we'll get a bit more into that training in a moment. Now, another testing reason here is return to duty testing and follow-up testing. Those, they're both similar in the sense that they're required for drivers who have tested positive, refused to test, or who have otherwise violated the DOT drug and alcohol regulations. And the return to duty testing is done for drivers who have completed what's called the return to duty process with a qualified substance abuse professional. And this test, the return to duty test, is directly observed, and a negative test result is required before that driver can then resume DOT driving duties. Follow-up testing, again, it's related to the return to duty. Follow-up testing is done for drivers who have completed the return to duty process and have tested negative on a return to duty test. The follow-up testing is prescribed by the substance abuse professional for a minimum of 6 directly observed tests within a 12-month period. And it can also be extended for an additional 4 years at the discretion of the substance abuse professional. And again, I'll get into the return to duty process in a moment, so it makes a bit more sense. And just so everyone is aware, driver check can help facilitate each of these various testing reasons for your work testing program. As mentioned previously, for reasonable suspicion testing to occur, the DOT requires a supervisor or company official to be trained in observing drug and alcohol misuse. And all regulated employers have to ensure those designated to supervise drivers receive at least 60 minutes of training on alcohol misuse and receive at least an additional 60 minutes of training on drug use. And the training will be used by the supervisor to determine whether reasonable suspicion exists to require a driver to undergo drug or alcohol testing. And the training must include the physical, behavioral, speech, and performance indicators of probable alcohol misuse and the use of drugs. Now, please note, under the FMCSA regulations, so very specific to FMCSA, recurrent training for supervisory personnel isn't required. So you don't necessarily have to refresh or retrain every year or even every few years. However, even though it's not a regulatory requirement, it is best practice to periodically send your supervisors for refresher training to keep them current, or, as supervisors come and go, as new ones come in, you have to train them. So also of note is that owner operators are not subject to DOT supervisor training. However, owner operators are still required to register with a consortium for drug and alcohol testing purposes. Now, some of you may already be aware of this and may have even used this service, but DriverCheck does offer supervisor training. So we have an interactive online supervisor training package, and it features things like learning at your convenience. Employees can stop and resume a session whenever they want to. It's self-managed learning. If you don't need to complete the course, you can simply access a refresher course or maybe even just a specific situation handling scenario. And on that, there are 19 different situation handling scenarios to help supervisors determine appropriate courses of action depending on what's happening. And our training also provides you with access to comprehensive knowledge base, and you'll get things like links to resources and procedures, forms, industry websites, as well as the regulations themselves. So now that you've heard a little bit of my sales pitch for DriverCheck, I'm going to move on to collection methods. So which collection methods are allowed to be used for DOT testing purposes? Well, for drug testing, we have urine and oral fluid. Those are the two different collection methods allowed for drug testing. So urine testing is completed by having the individual being tested void a sample of their urine into a collection bottle, and that is then sent on to a lab for analysis. And this is typically done within like a washroom setting, a washroom location. Now, oral fluid testing, on the other hand, is completed by having the individual being tested open their mouth and having the inside of their cheek swabbed with some type of absorbent pad or sponge, which collects fluid from their mouth, and then it's put into a collection tube and sent to a lab for further analysis. And oral fluid testing can be done pretty much anywhere, so long as it's done in a confidential manner and done in accordance with the regulations. However, and this is a big however, I need to mention that even though oral fluid testing is allowed under the DOT regulations, it can't be utilized yet, as two laboratories need to be certified by the U.S. Department of Health and Human Services before they can begin to receive oral fluid specimens for DOT purposes. So as of this month, as of June 2024, there haven't been any labs certified for this purpose. So we're going to have to wait a while longer before we can actually do DOT oral fluid testing. And in terms of alcohol testing, breath and saliva are allowed to be collected. Those are the two different collection methods. So breath testing, we're all pretty familiar with that. A lot of us call it the breathalyzer. Breath testing is completed by having the individual being tested breathe into what's called an evidential breath testing device, or an EBT, and a result is generated on site within seconds of the individual blowing into the device. And should that initial result show positive for alcohol, a secondary confirmation test would be completed just to confirm that initial result. And then saliva alcohol testing, that's done by having the individual provide a sample of their saliva through a swab or collection tube, and that's then placed onto a test strip, and a result is confirmed within minutes to determine if the individual is positive or negative for the presence of alcohol. Now, and I've got a lot of these special notes, but there's a special note on drug testing. So all drug testing has to be lab-based for DOT purposes, okay? And the laboratory that's used has to be HHS approved for DOT testing purposes. You can't just go to any laboratory and expect them to be able to do the testing and analysis for you. It has to be HHS approved. Now, this leads me to my next point, and that is drug testing can't be what's called point of collection testing or POCT testing, and or some of us refer to it as instant testing. Okay, so in other words, you can't use a test kit that provides a quick result at the time of collection. POCT and instant testing are prohibited by the DOT regulations. So also prohibited by the regulations are blood testing, hair testing, and DNA testing. Those methods of collection are not currently permitted. Now, I'm not going to spend a lot of time on this, but the DOT requires the following drugs or substances to be lab tested, and they are marijuana or THC, cocaine, opiates such as opium and codeine derivatives, amphetamines and methamphetamines, as well as phencyclidine or PCP. And should one or more of these substances show up in a specimen that's tested, the individual who provided the sample would need to undergo an MRO interview. And I'm going to explain the MRO process in a moment. Now, there's something very important to note about the DOT's position on marijuana. And simply put, it's not allowed, okay? It doesn't matter if you're using marijuana recreationally or medically. The DOT's position is that it's a violation to test positive for marijuana. Okay, I know there's, Canada's legalized marijuana, and a number of U.S. states have legalized marijuana, both recreationally and medically. Well, the DOT's position, simply put, yeah, they don't, not that they don't care, but to them, um, it's still a violation to test positive for marijuana. And here's a statement directly from the DOT on this. So marijuana remains a drug listed in Schedule 1 of the Controlled Substances Act. It remains unacceptable for any safety-sensitive employee subject to drug testing under the Department of Transportation's drug testing regulations to use marijuana. Okay, I just kind of wanted to hit that message home because I know a lot of people think, well, I can do it in my spare time, so it should be okay. Well, it's not. So once an employee has provided a sample of their urine or oral fluid for DOT drug testing purposes, it's sent off to a lab, and the lab's going to analyze that specimen for any of the drugs that I explained on the last slide. So if the lab identifies a specimen as positive for one or more substances, or as being adulterated or substituted, meaning someone tried to swap out their specimen with, let's say, they tried using fake urine or animal urine, or maybe they tried adding water to dilute their specimen. Well, it means this individual is going to need to speak with a physician known as a medical review officer, or an MRO for short. And the medical review officer has to be a licensed physician, and they also have to be certified. They have to be certified in the DOT drug and alcohol testing regulations, and there's various certification bodies out there that do that. And the MRO is responsible for receiving and reviewing lab results generated by an employer's drug testing program, and they evaluate the various medical explanations for certain drug test results. And the employee, so should somebody test positive, the employee would have an opportunity to speak directly with the MRO following that positive result from the laboratory. And during that interview with the MRO, the employee will have an opportunity to provide information or medical documentation to explain, why their specimen was positive, adulterated, or substituted. And based on that information provided, the MRO is going to then verify the result by determining if there was a legitimate medical reason for that test, and even if there was a legitimate reason for using that drug, was it done and used in a safe manner, in adherence with the drug and alcohol regulations. Maybe somebody's using a prescribed drug. Well, the MRO is then going to report the results to the employer after making their determination on, is there a medically valid reason for this? Now, you might be asking yourself, can I use medication and perform safety sensitive duties? So prescription medicine and over-the-counter drugs, they're allowed. However, you have to meet some minimum standards, okay? So medicine has to be prescribed to you by a licensed physician. This is assuming it's a controlled substance. The medicine has to be prescribed by a licensed physician. And then that prescribing doctor has to have made a good faith judgment that the use of the substance that they have prescribed or authorized is going to be used consistently within the safe performance of your job duties. So, as a best practice, you should consider providing your doctor with a detailed description of your job duties. That way your doctor can go, okay, no, maybe I need to decrease the dosage, or I have to give you a different type of medication because this one causes severe drowsiness, whatever the case may be. They have to make that determination, what's going to be safe for you, but also still get you that treatment that you require. And on over-the-counter medications, so those aren't prescribed, right? Again, you have to read the label of what's in that medication, that over-the-counter medication, and be cautious of what it says in the medical indications, whether the warnings, like, is it going to cause severe drowsiness? Is it going to cause some kind of impairment? And you have to be judicial about that in your use of that over-the-counter medication, okay? Now, as a good example of this process, let's say somebody's tested positive for codeine, and codeine's found in many pain medications. Now, as an employee, you might test positive for codeine at the lab, but once you've had a chance to speak with the medical review officer, it might be determined that the employee was using codeine as prescribed by their doctor, and it was done in a safe manner, consistent with safe performance of their job duties. And in that case, the MRO could maybe then verify the result is negative and put you back to, like, say that you're good to go back to work. On the flip side, you might have had a valid prescription, but you were overdosing, right? Maybe you're using double or triple the dosage your doctor prescribed. So in that case, the result might remain positive. And again, just to reiterate what I said a moment ago about medical marijuana, even though you might have legitimate authorization to use medical marijuana, and it was prescribed or authorized by your personal physician, the MRO is going to have to mark your test as positive, as the DOT doesn't allow for the use of marijuana. Okay. Now, please make sure that you take special note of the following stipulation in the regulation. So no one is permitted to change or disregard the results of a DOT test based on the results of a non-DOT test. So for an example, as an employer, you're not allowed to disregard a verified DOT test result because an employee presents you with a negative result from, let's say, a blood test or a test conducted by their personal physician. Maybe they brought in a DNA test and they're trying to question the identity of the DOT specimen that they originally did, provided. That simply is not allowed. Now, technically, there is a lot more involved in the MRO process, but for the sake of this webinar, I'm only going to touch briefly on this process. Now, I talked a bit about drug testing and what would be considered a positive violation for that, but what about alcohol testing? What's considered a positive alcohol test? Well, under the regulations, positive alcohol test or violation would be any of the following. So reporting for or remaining on duty, with an alcohol concentration of 0.04 or greater, and using alcohol while performing safety sensitive functions, using alcohol within 4 hours of performing safety sensitive functions, and using alcohol within 8 hours following an accident. Now, some of you might have noticed the DOT set the alcohol concentration limit at exactly half the legal limit, or what some of us would call the criminal limit for drinking and driving, which is 0.08 or greater. And I think the reason why the DOT did this, why they said it's, half of the legal limit, is that, these drivers, these commercial drivers are moving very heavy loads, dangerous goods, or lots of passengers, and typically in large vehicles at high speeds on very busy roads. Okay, so there's a need for drivers, for commercial drivers, to remain sober while driving to help prevent accidents from happening. You know, we all know the road is dangerous even on a good day, so why add alcohol to that mix? Now, one other thing I need to point out that's relevant here is that while it's not technically considered a positive violation, an alcohol test result of 0.02 or higher, but less than 0.04, means that that driver, that employee, has to be removed from safety sensitive duties for at least 24 hours. But after that point, they can then be returned to work. I'm going to sound like a broken record here, but I'm not going to spend very much time on this. But another item that comes up beyond a testing violation is what comes up beyond a testing violation is what's called a knowledge violation. And a knowledge violation is based on the employer's direct observation of the employee. So something like catching the driver drinking beer in their truck. They got a 6-pack of beer once cracked open and they're drinking it while they're right there in front of you. A knowledge violation could also be information provided by the driver's previous employer, such as a confirmation of a previous positive test result. It could also be a traffic citation for driving commercial vehicle while under the influence of drugs and alcohol. And you might find this out directly from the driver if you got a policy stipulating that they have to make you aware of such things, or perhaps you hear it from the grapevine. Employee A tells you that employee B got this ticket. Okay. Now, a knowledge violation could also be an employee's admission of alcohol and drug use, except for where provided in the regulations. So in terms of that exception, employees who admit to alcohol misuse or controlled substances use are not subject to referral, evaluation, and treatment requirements, so long as that admission is done in accordance with Part 382, 121. And just a little bit more about that. The admission has to be done in accordance with a written employer established voluntary self-identification program. Now, that's a mouthful. So, in addition to that, the driver can't self-identify drug or alcohol use in order to avoid testing. And the driver, uh, they must make the admission of alcohol misuse or drug use prior to performing safety sensitive functions. So the admission can't be done while they're performing their duties. So they can't be halfway between here and Albany, New York, and tell you, "Hey, boss, I just snorted a line of Coke." That's not going to fly. Okay. Now, the employer's self-identification program must prohibit the employer from taking adverse action against the employee, making a voluntary admission of alcohol misuse or drug use within the parameters of the program or policy. And the program must allow the employee sufficient opportunity to seek evaluation, education, or treatment to establish control over the employee's drug or alcohol problem. And the program must permit the employee to return to safety sensitive duties upon the successful completion of an educational or treatment program as determined by a substance abuse professional. Now, you might be asking yourself, what happens if somebody violates a drug and alcohol rule, such as testing positive for drugs or refusing to test? Well, before I get into the consequences any further, let me just explain what refusing to test means. So according to the regulations, as the name implies, the individual who is ordered to go for testing refused to be tested, including if they provided a verified adulterated or substituted specimen. Refusing to test also includes various situations such as leaving a testing event before it's been completed. They simply walk away, or being uncooperative or combative with the collection technician, or maybe they tried to sabotage the test kit itself or the testing device, or they tried to destroy or somehow interfere with the testing paperwork. Basically, what's happening is the individual isn't willing to allow the testing process to proceed in a normal way, or in some cases, they're not allowing the testing to proceed at all. So now that I've explained what refusing to test is a bit more, I'm going to get back to what the consequences are for testing positive or refusing to test. So while the employer is required to remove the employee from performing safety sensitive functions, and they're not permitted to return to regulated duties until they've done the following. So that employee is going to have to undergo an evaluation by a substance abuse professional, or SAP for short. And please note, the employer is responsible for providing the individual with a list of SAPs they can use. However, the employer doesn't have to pay for the SAP services. And then next, the employee will need to successfully complete any courses, counseling, or treatment that have been prescribed by the SAP prior to returning to service. And then the employee is going to need to complete a return to duty test and receive a negative test result before they can finally go back behind the wheel of a commercial vehicle. So it's a bit of a process to return to work following a violation, and it's referred to as the return to duty process. And I'll explain that even further in a moment. Now, another consequence of testing positive or refusing to test is having that violation entered into the FMCSA's Drug and Alcohol Clearinghouse. And I'll explain the clearinghouse a bit further in a moment, but essentially what it is a database of all FMCSA drug and alcohol violations, and each regulated employer is expected to keep tabs of the clearinghouse to determine which of their drivers has a violation and needs to be removed from DOT work. Now, a big question that comes up when doing drug and alcohol testing is, will I lose my job if I violate the regulations? Am I going to be unemployed because I tested positive or refused to test? Well, it's important to note that all employment decisions belong solely to the employer, and the DOT regulations do not address employment actions such as hiring, firing, or leaves of absence. The DOT and FMCSA regulations, they prohibit someone from performing safety sensitive duties after a positive test or refusing to test. But any employment consequences such as discipline or termination, those are based on the individual company's policies or employment agreements. And an employer may decide to keep a driver on board and even help them through the return to duty process. As previously mentioned, one of the consequences for testing positive for drugs or alcohol, or refusing to test, is having that violation entered into the FMCSA's Drug and Alcohol Clearinghouse. So what the clearinghouse is an online database operated by the FMCSA that gives employers and other authorized users information about commercial drivers' drug and alcohol program violations. And according to the FMCSA, the clearinghouse is meant to improve safety of American roadways by giving employers access to information they need to make informed safety decisions about which employees to place in safety sensitive functions. So employers have to register in the clearinghouse to meet their clearinghouse requirements, and employers are required to also conduct queries, which is, query is just a fancy word for search, or an alternative synonym for the word query. So why they're performing this query is to determine if a prospective employee has prohibited any of the regulations, and whether they can be returned to duty, where in the return to duty process is that individual. And employers are also required to query all current employees at least once annually to ensure their current staff don't have any unresolved violations. Now, employers are also required to report drug and alcohol violations to the clearinghouse for their regulated employees. And this includes, positive results, refusals to take a test, as well as knowledge violations. And employers are also required to report negative return to duty tests, as well as overall successful completion of follow-up testing plans. And owner operators are also subject to the clearinghouse requirements as an employer. So as an owner operator, you're going to have to go into the clearinghouse and register as an employer in there as well. Now, I could spend a lot more time on the clearinghouse. However, for the sake of this webinar, I'm going to keep moving things along. So as a consequence of violating one of the drug and alcohol regulations, drivers who wish to return to safety sensitive duties for DOT purposes must go through the return to duty process, or what's referred to as RTD. And as previously mentioned, should a driver have a drug or alcohol violation, they can't perform any DOT safety sensitive duties for any employer until they complete the SAP evaluation, referral, education, or treatment. And so how the RTD process gets started is when the employer provides the driver with a list of substance abuse professionals. And from that list, the driver will select the preferred SAP, and they'll then go for an evaluation to assess what treatment or education the driver needs in terms of their drug or alcohol use. And once the driver completes any of the treatment or education, the SAP has assigned them, the driver will then be eligible for a return to duty test. And should the driver decide to want to return the driver to DOT work, the employer will need to send the driver for a return to duty test and receive a negative test result. And it's only at this point that the employer can put the driver back behind the wheel of a commercial vehicle for DOT purposes. And on that note, I just want to mention the process isn't complete. The substance abuse professional is going to have to direct the driver to be subject to a minimum of 6 unannounced follow-up tests over a 12-month period following the return to DOT duties. And it's on the employer to then schedule those follow-up tests. And it's only once the driver has successfully completed all the follow-up testing that the driver will have finished the entirety of the RTD process. So the return to duty process, it's not quick, and it takes about a year to complete once all the evaluation and testing is done. And the process, it's certainly not free, right? The substance abuse professional services cost money, and the testing costs money. Now, with that being said, the employer is not obligated to pay for any of the substance abuse professional services. They don't have to pay for any education or treatment. That's on the driver, unless, of course, your company has in its policies and its agreements that you'll pay for those services. Now, one of the requirements of the FMCSA's regulations is that employers must have a DOT drug and alcohol testing policy and procedure in place for its regulated drivers. Now, I'm going to warn you, I'm going to bore you a little bit if I haven't already. I'm going to bore you a little bit with this next part, but here's a listing of what needs to be contained within an employer's drug and alcohol policy according to the regulations. So, number one, it's going to need to contain the identity of the person designated by the employer to answer driver questions about the policy and the materials. Number two, the policy will need to identify the categories of drivers who are subject to testing. Number three, the policy needs to have sufficient info about safety-sensitive functions performed by the drivers to make clear what period of the workday the drivers to be in compliance. Number four, it will need to have specific information concerning driver conduct that is prohibited. Number five, it'll need to specify the circumstances under which a driver will be tested for drugs and alcohol. Number six, it'll need to comment on the procedures that will be used to test for the presence of drugs and alcohol. Number seven, the policy will need to explain what constitutes a refusal to test. Number eight, it'll need to mention the consequences for drivers who violate the regulations, including removal from duty. Number nine, information regarding the effects of drug and alcohol use on an individual's health, work, and personal life. And then number 10, it's also going to be noted in the policy that the driver's personal information will be entered into the FMCSA clearinghouse should there be a violation or some kind of like return to duty or follow-up testing plan. Now, lastly, regulated employers must ensure that each driver signs a statement certifying that they've received a copy of the policy and related materials. And as a reminder, DriverCheck sells a DOT drug and alcohol testing policy template. Now, I'm just going to do a little bit of a sales plug before I finish, but I want you to all know that DriverCheck provides the following services as well as much more. So we provide DOT drug and alcohol testing, including mobile testing and MRO services for all reasons. We provide clearinghouse services, including violation entries, pre-employment and annual queries. We also do random testing selection and random program management. We do substance abuse professional referrals. We can provide supervisor training or reasonable suspicion training. And we also have occupational health testing, including things like provincial medicals and physical abilities testing. So I encourage you to visit DriverCheck's website at www.drivercheck.ca/services for more information. And with that, I think I can try and answer some questions now.
Thanks, Brandon. That's great. We've got a bunch of questions, but I'm also mindful of time. We're just about 5 minutes to the top of the hour, which is when we are scheduled to end. For those of you who can stick around, we're going to carry on for a little bit more, maybe about 5 or 10 minutes more to answer some of these questions. It will be in the recording, so you will get that as well. For those of you who have to drop off, that's fine. Please do. Before I get to the questions, Brandon, I just wanted to level set this. We're talking about DOT regulations, which really involve any employees who cross the border into the US who are regulated through the federal regulations. For all those attendees who are on this webinar that don't have employees who are crossing the border to the US, I just want to make sure that they understand that the DOT regulations, they don't apply specifically to Canada, but we use the DOT regulations as a best practice guide. So all the things that Brandon has been talking to you about DOT regulations still apply for Canadian drug and alcohol tests that we conduct in this country. So I just wanted to make sure that we had that in line. Maybe I can start with a question. It's a relatively easy one. If somebody tests positive on a DOT drug test, can this affect their ability to cross the border for leisure purposes?
So yeah, that's a good question. So if they test positive on a DOT test, no. For leisurely, recreational or personal reasons, no, it's not going to impact them. It's only going to impact them if they're driving commercially into the United States. Like if they're trying to cross the border in a commercial vehicle, like a truck, that'll be the issue. But if in your personal vehicle, it shouldn't have any impact on that entry.
Okay, thanks, Brandon. So another question, who's responsible for arranging a post-accident drug test if required? The employer or the police? I've heard lawyers recommend leaving it to the police to determine if testing is necessary. Is this accurate? Can this cause issues with the DOT FMCSA if testing is not completed in a timely manner or not done at all?
Yes, that's a very good question. I'm not going to comment on what the lawyers have said. That's their own, legal advice. But according to the regulations, the employer has to arrange for post-accident testing in some of the situations I described earlier, like if there's been a fatality involving a commercial vehicle or somebody needs medical attention away from the crash scene. The employer has to do that. And there are some hourly requirements on that too. You have 8 hours following the accident to do an alcohol test. And from what I recall, it's 32 hours to do a controlled substances or drug test. So you have a very limited amount of time. Now, I'm not going to comment on what the police will do. Sometimes, if the police show up and the police are like, oh my God, this guy is drunk, they might take it upon themselves to do testing right then and there, but then you're also expected to keep doing testing yourself in accordance with the regulations.
Yeah, and just to be very clear, what's a criminal investigation is very separate from the regulations according to DOT. So the employer is on the hook. If you don't do that, then you can't actually comment with respect to a violation of the regulations. So there's another question. Just curious if we are allowed to ask an outside carrier if their drivers are drug tested and what the clearinghouse results are, or if they're compliant, or what is the proper way to acquire that information before we hire them to haul loads?
Okay, so I'm going to assume this is you're hiring like an independent operator to all loads. You're responsible if they're going to be pulling your loads for you, and they're DOT regulated loads. You're responsible for ensuring that they are in compliance with the DOT regulations. So you're going to have to ensure that they've been doing drug and alcohol testing, and you should even ask or look into their clearinghouse violations. Okay, you can't just because you hired outside independent operators doesn't mean you can completely escape responsibility from the regulations. I hope that answers the question, but yeah.
Okay, I'm just mindful of time. We're at 2 o'clock in Ontario here. Before people sort of drop off, I just want to perhaps allow them to advance the slide to our Fitness for Duty Summit. Driver Check hosts an annual Fitness for Duty Summit. This year, it's going to be in the beautiful city of Calgary on October 22nd and 23rd. If you scan the QR code in the top right-hand corner, you will be directed to a place where you can access tickets. I'm going to keep this up. Please think about joining us this fall. We're going to continue on with some of the questions. For those of you who can't stay, please feel free to drop off. We will record this. We'll go for another 5 to 10 minutes and try to have some of these questions answered so you can get the recording, and then you can actually note the answer that Brandon is giving to you. So while this is up, Brandon, I'm going to sort of take you on with another question. A driver got a positive in the DNA random test. He finished the SAP program, but didn't show up for his return to duty test. The driver left the company and came back up after almost a year. Is there anything that we can do for him to continue the program and travel to the US again? So this is, an interruption in the return to duty test process where they get the SAP, but they don't do return to duty test. What happens then?
Yeah, so that's a very good question. And so it's good, and it should be noted in the clearinghouse. I'll say this: ever since the clearinghouse came into effect in 2020, the substance abuse professional would have had to notate in the clearinghouse that that individual, that driver, successfully completed their evaluation and treatment, and that they're eligible for return to duty. However, if the individual never did a return to duty test, including for you or another regulated employer, when you're trying to get that person back on board with you, you then have to check the clearinghouse, see where they're at. If they haven't done the test, send them for the test. Go and put them for a return to duty test and wait for the negative result.
Super. Okay, moving on. You spoke about a minimum annual random testing amount. Can you say those numbers again?
Yeah, so for the DOT and specifically the FMCSA, because there's other agencies within the DOT that have different random rates, but specifically for the FMCSA, for 2024 calendar year, it's 50% of drivers are to be tested for drugs or controlled substances, and 10% of drivers to be selected for alcohol.
Okay. So a couple of questions on the clearinghouse. So does an employee have to give consent to the clearinghouse to share information?
Yeah, they do. And there's two different kinds of consents. For a pre-employment, like a full, what's called a full query, where you get the employer gets full access to the clearinghouse record. Consent's actually done within the clearinghouse itself. So the individual driver, they'll have to be registered in the clearinghouse, as does the employer. When the the employer initiates that query, the driver will be sent a consent by the clearinghouse, and the driver will have to read through it and click, I agree. And it's at that point that the clearinghouse record would be released to the to the employer. Now, the other consent, that's kind of done on the back end, on the employer end, and that's for the annual limited queries. Those annual limited queries, you can go to each of your drivers, have them, sign and fill out a consent, and you keep that on file, on record in your own records. And then when you complete the annual query on, let's say you have 20 drivers, you go and do all the 20 queries on all those drivers, you already have the consent in place. Unless, of course, a violation shows up, in which case you have to then ask for additional consent. It's a bit of a process, but on that point, Driver Check does have that service available. We do help with consent management for clearinghouse purposes.
Thanks, Brandon. We have a number of other questions. We're not going to be able to get to all of them. I will just remind people that we will send out a survey to you. It's a short survey, 1 or 2 minutes to complete that. In that survey, there is a question to say, do you have any other questions? If we don't get to yours and you'd like to have an answer quickly, please respond to that survey. And one of our driver check colleagues will reach out to you to get those answered. Perhaps we'll leave this for one more question. It is also with respect to the clearinghouse, and then we'll close the webinar. What happens after a driver has a violation on their clearinghouse record?
So assuming they have a violation, whether it's drug or alcohol or refusing to test, and the next step is so that gets entered into the clearinghouse that by either the medical review officer or by the employer or their TPA, like driver check. What's supposed to happen is the employer removes that individual from safety sensitive duties, and that driver is expected to then go seek out the services of a substance abuse professional. And they do so by going into the clearinghouse. So the driver goes into the clearinghouse, indicates which substance abuse professional they want to work with. And then the substance abuse professional on their end will say, yeah, I'm going to work with this individual. And that will be notated in the clearinghouse. The driver will go for treatment or education. And again, notated in the clearinghouse. And it keeps going in a procedural step until the point where we get to the return to duty test, where the individual has to get a negative result in order to then go back to back to safety sensitive duties.
Great. Well, thanks again, Brandon. I think we will stop at that question. I'm sorry that we're not able to get to all the questions in the Q&A. We will attempt to answer that directly to you in an email, or if you do want to respond to our survey, which I encourage you to do, please ask that question again, and we will be answering that to you. So once again, thank you for joining us for this webinar. As you can appreciate, it's a bit difficult to navigate through some regulations. Driver Check is here to help you with our expertise and our 28-year history of doing this. We know what we're talking about. We can definitely help you get on the road to safety. One last point, please, again, consider joining us for our Fitness for Duty Summit being held in Calgary, October 22nd and 23rd of this year. If you liked some of this information, you want to see more and want to hear more, we have an incredible lineup of speakers who will be sharing their wisdom over a period of 2 days. Come out, join us for a good education session and a get to know us as well. Thank you again for attending this webinar. Bye-bye.